Hi, guys. Welcome back to episode 7 of Injustice for All with Judge Joe Brown. Um, and today we are going to talk about basically intimate domain. It was a story that came out recently.
Imminent domain.
How you pronounce it?
Imminent, like it's imminent to happen.
What did I say?
Intimate.
I know I said intimate. It's still
imminent. Imminent.
Imminent.
Like, when is this going to happen? Imminently.
And I think
You're
I did
about to
say
kick
that.
in the door right now.
Eminent domain. Correct?
That's it.
Okay. Well, that's what we're going to be talking about today. It was a story. Georgia family Blaine and Diane Smith fighting to keep their land in the state of Georgia. Oh, honey, Georgia got a lot of stuff going on. Fulton County, South Fulton, Douglas, just the whole state. So the Smith family owns 600 acres of land, which has been passed down in the family since 1920. A judge just ruled a railroad company could seize their land. So I want to play the actual clip.
Correction. They don't own land. They don't own whatever they have. You can't. The only thing you own in the United States is what they call property rights. That means you have the exclusive use of a thing vis-a-vis anybody else. The ownership of the object, the house, the land, the car, even yourself belongs to the state or the United States of America. They just give you the property rights, which is the exclusive right to use a thing. All title comes from the state, or if it's on federal property, the United States. So you can own nothing. You don't even own yourself. You don't own your clothes. You just own the right to use yourself. And when you don't exercise that right, you get hauled into a criminal court and they modify your property interest in yourself. So first off, that characterization is wrong. It's not their land. It's not something their family has owned. The only thing the family has a right to is the exclusive use of the thing. And since the whole scheme is based on the theory that the exclusive and self-interest of someone in a thing will cause it to develop for the benefit of the whole society, when that falls down, the state may dissolve your property rights in the thing, but they have to compensate you the reasonable value. And that's the only thing you have a right to, is the compensation for the reasonable value of your loss of the exclusive use to the thing or of the thing. Now, that's the clarification, and that's where the difficulty comes in, because people say, that's my house. No, it's not. You have the rights to the use of the house. If you built the house on the place, you donated that to the state wherein you built it, but you get the right to use it. When you get the car title, it comes from the state. So what you get is not ownership of the car, you get ownership of the rights to use the car.
Okay.
See?
Okay.
With that clarification, so we don't start down the wrong track in terms of what we're discussing.
Driving across their nearly 600 acres.
Yeah, you can see a lot of the trees over there. You see the tops of them.
Never gets old for Blaine and Diane Smith. The history just as rich as the timber crops they've been farming.
We used to go down there. It's a special rock that we like to sit on.
Blaine's enslaved ancestors lived and worked on this Sparta land. Now, he and his wife own the very property. The family among the less than 2% of black farmers nationwide.
My father farmed this land almost all of his life. My grandfather farmed it most of his life. He bought it back in the 1920s. During that time, he raised cotton, corn, peas, all kinds of vegetables. But it's still in the Smith family. Not one piece of it has gotten away.
Until this September. State leaders decided parts of the Sparta land are no longer theirs.
It's my property. You know, you don't have the right to take
But a private company does have the right to take it, according to the unanimous vote from the Georgia Public Service Commission. The agency, comprised of 5 elected officials, oversees eminent domain. Eminent domain, the right of a government or its agent to appropriate private property for public use with payment of compensation. In Georgia, the process starts by first condemning the site. The Georgia PSC members agreed private company Sandersville Railroad could legally condemn 9 properties in Sparta, including parts of the Smiths, for the company's Hanson Spur project, a 4.5-mile spur connecting raw material producers to the CSX rail line in Hancock County, essentially hauling rocks that be used to build concrete. The company argues the train project will improve infrastructure, but the Smiths feel railroaded.
If you listen to the railroad folks, they say you're keeping your land. We're just taking a little piece of it. To me, we've got somebody who's coming through it like they are. They're devaluing it. They're defacing it. They're creating hazards through it.
They are just one of at least a dozen local eminent domain cases in recent years, from Atlanta to Newton County. Current statistics are few and fragmented, but Atlanta News First Investigates found nationwide data. A 2007 study revealed when eminent domain was used for private development, it most often impacted areas where more than half of the community was made up of people of color. Nearly half of the area's population sat below the poverty line. In the city of Sparta, where the developers are building the railroad, census records show 51% of residents live in poverty. The median income at $22,000.
Yeah, we're here in a county that really needs new opportunities, new job growth, new tax base.
The railroad company president, Ben Tarbutton.
Have an annual impact of $1.5 million.
That could make sense for a struggling town. It's how the company has pitched the project to residents. However, Georgia law states economic development is not a justifiable reason to take property.
It really is not supposed to be factored into an eminent domain case.
Well, they go hand in hand. I talk about jobs because that's what really matters to folks.
Tarbutton says the train would only travel 1 round trip per day, 5 days a week during daylight hours, that it would not be a nuisance to landowners.
They feel like you guys are robbing them of their family legacy, of their family land.
Well, I understand that, and it's the condemnation process is a last resort. We have had multiple conversations with the landowners.
While several other property owners made deals with the company, 3 families are holding out, including the Smiths, in part over fears if they give up land now, the company could take even more.
Would you guys come back and take more land?
Well, I don't know exactly who you're talking to, but everyone I've dealt with that's a landowner, we've had very constructive dialogue.
So would you take more land if you needed it?
No, we're very clear.
A claim the Smiths don't believe.
Because when they come and take that property, it's gone forever.
It's why the Institute for Justice now represents the families against the railroad.
The railroad's position is just that I'm a railroad. Obviously, I'm going to benefit you, and that's just not enough.
The attorney filed this appeal in Fulton County Superior Court, alleging the PSC improperly granted Sandersville's petition that the project is not economically feasible and may not be a legitimate public use.
What the railroad has shown is that this track, if it even comes about, is going to promote the profits and the cost reductions for a couple of private companies, and that's all.
The Institute for Justice is using this as a money-making venture for themselves.
Hundreds of acres for 100 years and one single lineage. Altering it in any way is a price of progress that's just too high for the Smiths.
I go back to what my father said, keep the land. The land gives you respect, gives you respectability. Everybody around here knows that this is the Smith land down here.
So, your thoughts?
They'll lose. Because, again, they think they own the objects in question. They don't. They just have the right to the use of the object, and anytime the state wishes to revoke that, it's not the right of that statement that they printed out is wrong. It's not the state's right. If I'll read what it is, government has authority to revoke property rights with compensation.
So here's my question.
And by the way, you don't own land. The correct term is landholder, because the sovereign entity owns the land. If that was not the case, it would be the United Parcels of, or the United Parcels of the state of Mississippi, where everybody in there was in a long laundry list as having owned this piece of the administrative entity known as Mississippi or Alabama or Georgia, Tennessee, New York. It isn't. It is the state of New York, the state of Georgia, and no one has the overreaching authority to the territory but the state itself. So in England, you hold at the pleasure of the monarch. You hold the king's land or the queen's land. You do not own it. A landholder.
My question, it's not the state that wants to take the land, it's a private company.
It doesn't make any difference. It's like if the state says these people have a better use, they can do that. And then your precedent is you got to get a real mess on that. You've got scads of federal legislation dealing with railroad right-of-ways, and the United States would not be what it is today without the railroads. Southern Pacific, Union Pacific,
CSX.
all of the right-of-ways that they got when railroads were new, from coast to coast, border to border on this continent, you have to go against that. So railroads are extremely vital to the economy and the industry and the well-being of the United States. So most heavy freight, when it comes to continental United States transport, travels by rail.
Mm-hmm.
Large part of it is by trucking. And a lot of our laws right now, hell, what I did on the show has got to do with the competition between the railroad industry and the nascent, now well-established trucking industry. See, I did what I did, according to the U.S. Supreme Court, under, quote, the United States Arbitration Act of 1928, which was set up to give the nascent trucking industry a break from the hegemony of the railroads. So that's how I did on what I did on the Judge Joe Brown show, and what I did was enforceable in any state as a matter of binding contractual arbitration, which is under that particular statute. Now, when you get to this, somebody can say we want to build a mall, and if the repository of authority, the administration of a sovereign entity, be it a township, municipality, city, county, or state, says we think it's in the best interest of the people to let this mall be put in, to let this office building complex be put in, and the rest of you get on out of the way. So we now are confiscating your property interest, but under American law, you have to be compensated. Now they're talking about logging and felling trees, and from what I'm looking at, 600 acres, that's going to be a few tens of millions of dollars. They might as well take it and invest it, because they'll get a great deal of capital, and they don't need to burn up too much with attorney fees, because unless there's this palpable wrongdoing, And even then, getting redress is going to be very expensive and likely to be fruitless against the authority of the state. They would do well to cut their losses, accept it, and take it. And then what they're actually talking about is not even taking, per se, the entirety of the property. They're talking about exercising a right-of-way easement for the railroad. You see, under U.S. law, railroads have easement rights, which is if they have to go this way and you've got something that goes that way, they got a right to go right through you. That's like you have that kind of right too. For example, if you acquire by one means or another what's known as a landlocked property, in other words, you have no way to get from your property to a highway, you have a right to an easement through the nearest property that will get you to a main thoroughfare. So that goes all kinds of ways. So they're going up with
questions. I have a couple of questions because
last little quick comment. Mm-hmm. The law on this is about 2,000 years old.
Which law?
The one about who, eminent domain, it comes from 2,000 years worth of law.
So this situation with this couple, they have all their paperwork together. It is not a situation to where we talked about before with Silver Dollar Road or other specifically Black people and people in general, where their land is taken away, but they didn't have a will. So it's easy for an outside entity to create a fake deed and come in and claim your land or your home. This is a situation of eminent domain, and the people are refusing to hand over a piece of their land to the railroad, even though they're going to be compensated. So the question I want to ask you, explain the definition of eminent domain. And because one second. Because now how I'm looking at it, you have corporations, which is considered a person, and then you have real actual people. But it seemed like the corporation always gets the side of the state and the law over people.
The sovereign entity may determine how its territory and resources are used. That's their absolute discretion. Slam dunk. If you want an example, I already mentioned that you are a resource of the state. What you just posed as a question is the same as some parents posed back in the 1960s. I only have one son and I want grandchildren. Why can't he be exempted from the draft? Too bad. He's our resource. We just drafted him because his body belongs to us. And if he gets shot up in the Nam or killed, he's a resource of the state. That's at the bottom here with this birthright citizenship. If a child is born in the United States, that is someplace subject to the laws of the United States, quote, they put it in old time fashion, subject to the jurisdiction of the United States, that creature becomes a resource of the state. And when it gets 18 years old, it can be conscripted or drafted, in other words, and sent to the military and become part of the armed forces of the United States. So we have a large army again. And some sergeant can say, you, and you're going to advance on that machine gun emplacement. You, and you're going to lay down a base of fire. I'm not doing it. Okay, bam, right in the head with the service sidearm, which is what the sergeant can do when somebody refuses an order in combat. Now, that's where you are. Same thing. You have no option. Now, there might be some political consequences for somebody saying, we have these guys that are favored. And as a matter of fact, most of this superiority, because of the mass impact it has on the economy and enterprise of the country, the railroads did buy off a lot of people. But there are easements that the railroad has stretching from coast to coast, southern border, the northern border, east coast, the west coast. And there's no way around it.
So
And it
another
doesn't make
question.
any difference if it's a cartoon show. If the state, the sovereign, thinks it is of more interest, bam, there you go. But they're likely from these timber rights, and I know because I've had in years past to get clients get their property evaluated for that. That's likely to be tens of millions of dollars, cash in hand, and it's time to move on. It does not make any difference what the deal is. It is the exclusive domain of the sovereign to determine what its territories and resources are going to be used for.
So the question I want to ask you, people who own land in Texas, oil companies lease the land from these people and they pay them millions of dollars annually. So why can't railroad companies lease the land from people when they want to have their railroad tracks go through someone's land? So why can't they lease it instead of buying it from them?
Because nobody owns the land to begin with. And what the oil companies are doing, they have bought into the property interest of the landholder so that they get a percentage of the mineral rights. Or if they drill and they get oil under the property rights of a landholder, they pay out a certain amount of money. Technically, the state of Texas could come in and confiscate the property claims of everybody involved and lease them out directly to the oil companies after compensating the people who held the surface rights to the use of the land. It is important to understand that we should not continue to talk about landowner because that is a fairly recent terminology, and you say it often enough, long enough, and just like a lie, it becomes believed. And Americans don't know their system because of a continuation over the last few decades of egregious errors in the way we look at stuff. We do not have landowners in Texas leasing out anything to the oil companies who pump oil below their land. The landowner is not such. It's a landholder. She doesn't own the land. The oil companies don't own the oil under the land. They own the rights to the use of the oil. And that is something that is granted to them by the sovereign entity. Now, we need to start thinking in terms of what the realities are so we don't get any more stupid than we have become. Now, that's what the problem is with these people. So, yes, a railroad could come in and say, we want to lease this strip of land across your property. They have that option. They also have the option of saying, state, we wish you to confiscate this strip of land so we don't have to be bothered because our convenience will be more for the benefit of the state. And that can be done. The oil companies don't have to lease it. They could come in and say, we want you in the state to exercise eminent domain and confiscate the use of the mineral resources under this particular plot of land and let us use it. They could do that. Mm-hmm. It's just what is most convenient under the circumstances. That's all it is. And the equation is like this. To break it down, let's suppose you rent an apartment. Does that mean you own any interest in the apartment building? No, it's not. You lease it. If it is a situation where your uncle finances the apartment building and he tells the people who manage the apartment building, you let my nephew stay in that apartment free. That does not mean that the nephew has any interest in the apartment building other than as a tenant. That's the same way. When you hold land, you are actually legally and by definition a tenant of the sovereign, which in this case is the state. So actually where this whole principle came from is when Baron Wilberforce had the castle. He was a tenant of the king, and he held the king's land for the king. So when somebody is in this situation, these people who have this ex-slave land down there, they are tenants of the state of Georgia, technically. And when you discuss it at length and in detail in law, they are tenants of the state. So what happens is the landlord, the state of Georgia, simply says, we don't have a lease here. What's going on is I'm canceling your interest in being a tenant, and this is what I'm going to pay you. Now, the remedy is for this family's lawyers to make sure that when the proceedings go down in the court with the requisite jurisdiction, their clients get the maximum compensation. That's all there is to it. Okay. What they're calling landowners are only tenants of Georgia. The people that are interested in the oil revenues are only tenants of the state of Texas. They are not owners.
Right. So I have one more question, because
go ahead.
The way you just explained it, right, it's basically the state, the sovereignty of that particular state or any state is to make sure that the state stays in power over the people. And by way of doing that is creating a culture of misinformation. Quick example, when you purchase your home and you get a mortgage, they will say, oh, you're the new homeowner, blah, blah, blah. They always use the word owner, landowner, homeowner. And we interpret it as we own it. But that is like a culture of misinformation, to whereas technically and factually, you are not the owner. It is the state, that sovereign state. And the states created it that way. Yes or no? They created it that way to make sure that they have more power than the people or any corporation.
What state do you live in?
Ohio right now.
Okay. Who is your congressman or congresswoman?
Who is Bernie Moreno and a couple other people.
Okay. Who did you just leave out?
I'm sorry, not Marino. I voted for the new guy. I forgot his name already, but
okay.
Yeah.
But who's your senator?
I mean, he is the senator.
Well, who's your congressman?
Oh, like the House of Representatives?
Yeah.
I don't know. There's so many of them. In my district?
See, that's the problem. Article 1 of the Constitution says the Congress of the United States shall consist of two chambers, the House of Representatives.
Oh, I was correct. It is Bernie Moreno. It is Bernie Moreno. I was correct.
Yeah, but listen,
the old one. Forgot.
Article 1 of the U.S. Constitution says the Congress of the United States shall consist of two chambers. 1, the House of Representatives, and 2, the Senate. Now, we think of the people that are in the House of Representatives as congressmen, because back when the newspapers started doing their thing, there was only one category that could be elected: the people that were in the House of Representatives. The senators were appointed by either a state governor or a state legislative body. So the people you voted on when they did this prior to the 17th Amendment were automatically going to be representatives. So the newspapers just say you're voting for your congressman because that was the only category you have. So nowadays we think Maxine Waters is congressman, not senator, and all this other stuff, but she's not, because you also have to include the 2 senators for the state of California in that category. But that is wrong conditioning, and after a whole bunch of time, most of the people in their ignorance don't get it now. They used to be taught it in the 5th and 6th grade, but now they don't get it because they haven't. So they don't understand that when you say Congress, you're talking House and Senate. You're not talking just the House.
Right.
So that is one of these things where misinformation, since the woke far left is so fixed on the term, has been spread until people take it as the truth when it is not. Landowner is one of those pieces of misinformation that has been repeated so often that people don't get it. Everybody at one point in this country knew you held land. You did not own it. You did not own your cabin. You held that improvement on the land that you held. Now, let me give you a thing that most people don't get. When you have a state, you have a nation. In political science, what you call the United States, what you call Italy, England, France, Germany, Greece, is known as a nation state. State and a nation are synonymous. We could say, instead of the United States of America, we could say the United Nations of America. So what happens is when you have a nation state, you have three things. You have one, a territory that is embraced by a boundary, a border. Two, you have a population. And three, you have a governmental entity that directs the interaction between the population and the territory. And that means handling the weather, the water resources, mineral circumstances, the general resources of the territory. So you make this nation state, this triumvirate, stronger in the environment of the world to deal with other nation states who may be in competition. Remember, this stuff arose over thousands of years, where Rome decided it was going to go into Gaul, and Caesar was going to come along and do what he did and conquer Gaul and then go in and invade what became known as England. And then he tried to get into Germany, but backed out of it. You see, this is the where it goes. When you are a German, and the Latins in the Roman legions, you know, they've got their eagles and their standards, and they decide that they're going to annex your territory and change the way you do your life business. You have an interest in protecting where you are from these Roman legionnaires. The way it worked out is the Roman legions whipped ass, and then the grandchildren and great-grandchildren of the conquered people wound up becoming members of the Roman legions, and some of them became members of the Roman Senate, and some of them became part of the Roman aristocracy. Rome was an idea. So that's the same thing we have now. All of this several thousand years of history where the king says, Baron, you are a strong man. You have protected my interest. I am the king. I am giving you this tract of land to hold. Remember Sherwood Forest, where the Sheriff of Nottingham was holding forth because King John, prior to that, King Richard had given him the holdings. And you say, my holdings, that's the way people used to do it. If you read the American case law up until around the last 80 or 90 years, somebody talks about my land holdings, not the land I own. So that's the whole thing. You hold it for the sovereign. In this case, it's we the people, rather than his majesty or her majesty, Queen Elizabeth. You see where that goes?
No. And that makes perfect sense because queens and kings, like when you watch these movies or these documentaries, when they would, let's say they title someone a duke or whatever, and he said, I give you this land and this castle, but they could take it back anytime they want.
Yeah.
We don't have kings and queens. So in our heads, you can't do that here because we don't have kings and queens. But it's like, okay, we don't have that entitled, but our system is still set up to where a state, which is a sovereignty, can say, no, you are not the owner. I am. You're just
okay. Let me
placeholder. What do you call it? Placeholder?
You hold the land. You're
hold the land. Right. You're not the land owner. You just hold the land.
You belong to any clubs or organizations?
I used to, but not now.
Okay, let's say you belong to a sorority. they've got a sorority house. Does any one person in that sorority own the house, or does the whole sorority own it collectively?
I'm going to say collectively. Yeah.
Okay. Now, how about a church? Some churches, the deed to the property is held by the whole church as a collective. Some churches have been silly enough to turn it over to a preacher who's likely to be a pimp preacher, and he owns the rights to the sanctuary.
Right.
All right. So, in other words, what's going on is in England, the preacher that held the title to the sanctuary would be the monarch. And in a situation where the church itself as a collective holds the title to the sanctuary, that would be the United States, where it's the congregation that collectively owns the interest in the sanctuary. You get it? So we are a collective that we own as a collective, like we are a congregation. And in England, the principle started out, it was the pimp preacher who had the deed to the sanctuary in his name.
Okay.
Get it?
Right.
That's
No, I get it.
Now, I mean, once you get it,
yes.
actually, it sounds complicated at first, but once you get the concept, a whole lot of other stuff gets simplified. In other words, what happens with these people who have this territory here that they're talking about? They've been farming it for years. Let's assume that they're church members, all right? And their congregation owns everything in terms of the rights to it in Georgia. So can they come in and say, our people paid some tithes 100 years ago, so now we claim the right of ownership of these pews in the church? And the church says, no. We've decided that we've expanded the church. We need these pews for the new members. So you can't claim that. You don't own this church. We all do. You got it? And in England, the king, the current king, owns all of that. What do they call the British Navy? The Royal Navy. Why? Because literally the Navy of England belongs to the monarch. They call it the RAF, the Royal Air Force, because the Air Force belongs to the king.
Right.
Now, there's one thing that doesn't belong to the king. They don't call it the Royal Army. You know what? Because that belongs to Parliament. That was Oliver Cromwell, who had the king executed when he deposed him. So as a representative of Parliament, his successful army, the Redcoats, that army belongs to Parliament. So when it's the land, the Parliament owns the military, and through Parliament, the people of England own their military, whereas the king owns the Air Force and the Navy.
Okay.
You get how that works?
No, I totally get it. I understand it. And it's not me understanding it. It's for you guys, the audience, including myself. It's for all of us to understand, because yes, we have been brought up even in adulthood in a culture of misinformation, and it is to make sure that the sovereignty stays in power. But knowing this knowledge, and it's not like, oh, it's a bad thing, because hey, if you are a what are we calling it, placeholder? I'm saying placeholder now. I'm not even saying homeowner or land owner, but when you occupy, when you have a mortgage, you could make money off it. You could rent it out, and it's an income. So it's not like the state is saying you don't own it. I do. Okay, I give you rights. Can I say the state gives us rights to occupy this space?
Yes, it does.
And you can
And,
make
and
profit.
look, it's like
And
the Baron.
you can make profit off it.
Yeah, like Baron Williams or Baron, whatever it may be, holding land for the King of England. What happens is he gets an income from holding that land from the peasants, the serfs, and the yeomen. And part of that income is supposed to be spent on setting up retainers, knights, and men at arms. So when the king needs him, he can do military service and become part of the king's army. Now, I want to expand into one slight thing that we need to touch on, because I'm sure there are listeners that don't get it. They keep thinking that each individual is sovereign in the United States. He or she is not. The phraseology is, quote, we the people, W-E, quote, on each side of that. We as a collective, not you as an individual. So when you walk into a courtroom, my courtroom, and I'm sitting as a Tennessee trial judge over a division that handles criminal matters mostly, what happens is you're in there because you got indicted. It says at the top of the indictment, the people of the state of Tennessee versus John Jones or John Doe. It does not say each individual and list them versus this person. It's the people. So when they come in there and they start saying, I don't consent to the jurisdiction, say it doesn't make any difference. You're an individual. You individually have no sovereignty. You, as part of a collective, have sovereignty. So we say all 15, 20 million people in the state are the sovereign entity, not any one particular one of them.
Okay.
Get it?
Yeah,
So they go in there, and what I would do is a simple illustration. I don't choose to submit to the court because I exercise my right as a sovereign entity to withhold consent. Officer Williams, Officer Duckett, Sergeant Tharp, see if your keys to lockup still work. If they do, escort him back into lockup and hold him until further notice. Bring him out a few hours later. Now, you see what that is? Could you resist? Do you have a sidearm? You went through security down there. You don't. They frisk you, but they do. That's the power of the state. Therefore, acting as the agency of the state, speaking for the state with the duly vested authority. Don't you try that nonsense again. You do not exist as a sovereign entity. You are part of a sovereign collective. It's like, are you the whole football team when you step out on the field? If you play football and there are 10 other people on the field from your team at the same time, no, you're not the whole team. You are one of 11 people on the team. You are part of the team. You're just one of the players. The team wins the game, not you.
All
Now,
right.
with that in clear, sit down and keep your mouth shut until we come to your case.
All right. I want to
Now,
swing.
boom.
I want to switch gears a little bit. These are quick takes. No more than 5 minutes for each one. I want to bring in the topic of activist judges, right? That's the slogan that's going around now, because you have judges that are blocking President Trump's executive orders. So now they're calling them these activist judges. You've heard that term recently, correct?
Yeah.
So what are your thoughts on it? Because one in particular, a judge went in, and it was a federal judge, halts Trump administration plan to transfer the detained Venezuelan migrants to Guantanamo Bay. Should a judge be allowed to stop the transfer of illegal aliens out of the country? And also, should judges step in and stop a sitting president from such executive orders?
Okay, yeah. All right. Let me be simple about this. The judge has the authority. Whether he exercises it wisely or appropriately is another issue, but he has the authority. Where do we also see that? Those of us who support the Second Amendment rejoiced a few months ago when a federal district court judge in Texas enjoined ATF from enforcing the Biden administration's dictates that pistols with a brace on them would be illegal. So he enjoined them from enforcing that edict and enjoined the Biden administration. Now, what happens is the case works its way up. The judge has the authority under the Constitution of the United States and under the oath that the president takes upon assuming office. He is bound to and required to follow the law, which includes what judges say it is. Now, the U.S. Supreme Court is the only one that's specified in the Constitution as a specific court, but the Constitution also says that Congress, House, and Senate may create such lesser courts as necessary. Now, activist judges, there's one problem with that. Again, it's shown by ignorance. And been so much as the very first case the United States Supreme Court heard back in the 1790s, case number 1, volume 1, had to do with this. The Sixth Amendment says, no matter tried before a jury upon the common law shall be heard upon appeal except upon application of the common law. That's a quote. What does the common law mean? That's the question. Well, the U.S. Supreme Court unanimously said, quote, the common law is that body of judge-made law based on tradition, precedent, and the evolving conditions of society, unquote. They were quoting a 1661 case heard before the English House of Lords with favor. They further elaborated during that unanimous decision. They said all law in the United States is common law until it is superseded by legislative law. In other words, all law in the United States is made by judges until a legislative body supersedes them and passes a statute. Now, what is judge-made law? Well, okay. Anytime the judge is charging the jury, let's say with first-degree murder, armed robbery, kidnapping, extortion, whatever it may be, he is going to charge the jury with this. The defendant is innocent until proven guilty beyond a reasonable doubt. What does reasonable doubt mean? The jury isn't just turned loose to use their imaginations. The judge tells them what reasonable doubt is. But reasonable doubt is not contained in any statute. What it is contained in is the instructions. There is in every state volumes of suggested jury instructions. Well, in 92, yours truly got taken up to the Tennessee Supreme Court because I refused to use the pattern jury instruction. I didn't like it, and I substituted my own. The Supreme Court of this state noted that Judge Brown, in fact, did not use the pattern jury instruction. However, we find that was not an error. In fact, henceforth, we are adopting Judge Brown's instruction on reasonable doubt as the official pattern instruction for the state of Tennessee, which it remained for almost 30 years. Now, that means that I, as an activist judge, decided to revise the law in the state of Tennessee by coming up with a common law edict as to what reasonable doubt was. So every time somebody came into a courtroom charged with a criminal case for the next 3 decades in the state of Tennessee, and the judge told the jury, which was a mandatory part of the jury instructions, you have to find the defendant guilty beyond a reasonable doubt, and that comes out of the Fifth Amendment and the 14th Amendment, by the way, when it applies to the states, and to the U.S. government, a judge, me, established what the law was. So when you have these judges that do these kind of things, it flies in the face of what the American law actually is. People say the original intent of the founders. Well, these 9 justices in 1792, I think it was, all of them had either signed the Declaration of Independence or had been delegates to the Constitutional Convention or had fought in the Revolutionary War, so they certainly knew what the Constitution and what these terms were about, and they were privy to the original intent. They were there.
Okay.
So that is what the rule is, in spite of what people holler about. Now, since these judges are part of the lesser courts that Congress has the authority to establish, what happens often is you get a judge here in Wyoming, 1 in Illinois, 2 in Illinois, 1 in Alabama, 1 in Tennessee, 2 in New York, 1 in New Mexico, and they all rule differently on the same issue. What happens is that district court judge's ruling goes up to a circuit court of appeals. There are 10 of them in the United States. And what happens is either the 3-member panel or the full panel of 9, or in the 9th, they have 11, but only 9 sit at a time. They hear the matter and they rule on it. Now, if somebody doesn't like what the Circuit Court of Appeals comes up with, whether it is the 9th, 10th, 5th, 6th, or whatever it may be, what winds up happening is they apply to the U.S. Supreme Court to hear the matter. The U.S. Supreme Court will briefly review it, and they will decide in a vote amongst themselves whether to hear the case. They will issue what's known as a writ of certiorari, which means we'll hear the case. They call it cert. In other words, the Supreme Court says we'll hear it, or they may deny it, which means it's left where it was when it got through the Circuit Court of Appeals, whatever that is. Okay. So what happens is it works its way up. A lot of times people go through these panics of so-and-so's defeated because the Supreme Court denied. No, all they did was say the record's not complete. We don't have a firm issue in front of us. You have to articulate it and put it on the record. So we're sending it back for you to do that. When you do it, then come back up again, one step at a time.
AG Pam Bundy just announced she has charged New York Governor Kathy Hochul and Letitia James for failing to enforce immigration law. So let me play this clip real quick.
We're here today because we have filed charges against the state of New York. We have filed charges against Kathy Hochul. We have filed charges against Letitia James and Mark Schroeder, who is with DMV. This is a new DOJ, and we are taking steps to protect Americans, American citizens, and angel moms, like the mom standing right behind me, who you're going to hear from in a moment. New York has chosen to prioritize illegal aliens over American citizens. It stops today. We're here.
So she also filed a lawsuit against the state of Illinois as well. So I wanted to get your quick take on this.
For the last year, I've been regularly publishing on X my observation that all of this sanctuary city stuff, this effort to thwart ICE, is in violation of Title 8, Section 1324 of the United States Codes, criminal codes, and it carries penitentiary time. Last time we were on, I spoke about this, and I said they're going to get these people because they're violating the law. They're harboring federal fugitives. It is specifically against the law to set up a sanctuary. So every governor, every prosecutor, every sheriff, every mayor that's been doing it, looks at something that on the low level has a 5-year cap in a federal penitentiary, and in the moderate level carries a 10-year cap. I represented people 45 years ago in federal court who were charged with such offenses. Now, if that's the case, this is nothing surprising. I've elaborated on it a while, and she didn't do us the favor of telling everybody what the code section was, though I have been publishing it. In fact, I published it 7 times in the last 3 days on X, where I presented a copy of the code as a photo shot with some remarks about this, and I was waiting on it. So now she does what is predictable. And last time we were on with Injustice for All, I talked about the forbearance that the Biden era prosecutors had for this, where they declined to prosecute because of the principle under American and English law that a prosecutor has absolute discretion in what to prosecute or not prosecute, unless perhaps a grand jury intervenes acting independently. So we have had the Biden administration, the Obama administration showing forbearance to enforce the law by simply not prosecuting somebody. I said last time we were on that sooner or later, probably very much sooner than later, we're going to get the new attorney general saying, hell no, we're going to prosecute it. It's under Title 8, Section 1324 et seq. That means what follows after that these prosecutions come from.
Mm-hmm. And so criminal lawsuit or civil lawsuit?
Criminal. One, it's an action by the United States against a state to enjoin them. And 2, it's going to morph into an action, a criminal action against the parties interested. Now, why is it of interest to the rest of the United States? Well, starting this May, in a month and a half, you will not be allowed to get on an airplane unless you have an official identification source, such as a driver's license with a star. Why do you need that? You didn't until California and New York started issuing intentionally driver's licenses to known illegal aliens because they thought it was the nice thing to do. Now they effed it up for everybody in the country who has to go through and now get a new license, which means most likely you will have to present your birth certificate, which imbecilically enough, a lot of states won't issue a new birth certificate or a copy of it unless you present the driver's license that is shortly to be invalid to validate your claim for a birth certificate to get a new license, which is crazy. So that is a problem. That kind of thing that New York has done, that California has done, has screwed 360 million people. Now we are expanded to about 410 million people because of the illegals that have come in. You want to get a clue as to how many people this is? In World War II, Nazi Germany had about 60 million people in it, combined with maybe 30 million from Austria. These illegals have come into the tune of 50 million plus. In other words, there are more illegals we let in than lived in Germany during World War I. And almost as many lived in Germany in World War II. That's what we did. And thanks to that, we've got screwed. Now, I'm waiting on my birth certificate, been waiting since July. I've been in touch with them, and there's a big screw up with them to get my birth certificate or certified copies from Washington, D.C. so I can renew a passport and get the new star driver's license. So it's fast on rushing. Time will be out. But you see, these bozos did it.
All right. So, and with that, that is all for episode 7 of Injustice for All. Thank you guys for tuning in. Make sure you hit the like button, share this video, and comment below and share your thoughts on today's video. And everybody have a wonderful week. And the judge will see you
Read the
next week.
Constitution. It'll take you 15 minutes. Just do it.